Okay, that was the resolution. The reason did you folks receive a copy of that?
Not sure what you're referring to. I don't know anything about it.
Donna Tope's motion to remove and expunge the court's order for contempt. Okay.
I don't know. I didn't think I was.
Not received. You got an email copy. All right. So then we received, and I guess I'll deal with that one first, if you don't mind. We received then a communication from Ms. Tope that she was unavailable for her own motion today. So that motion, Donna Tope's motion, will be adjourned. And I'm not changing anything. The bench warrant is still outstanding. So my next day.
March or April 14th.
14th?
Yeah.
I'm a little busy that day. March 17th, 2026, 9 a.m. So that I'll adjourn the Donna Tope's motions. Council, I'll leave it to you, given your motion to withdraw, as to whether or not you want me to finish ruling on the other motions or hear your motion to withdraw.
What it's my understanding, the last hearing you ruled or granted liability or the motion to stop the motion, and we're here today for a hearing on damages, which I suspect we're prepared to move forward with that might result in the conclusion of this matter, which might make my motion to withdraw moot to a certain extent, and also make the defendants, we're calling it the second omnibus motion, might make
Pardon?
moot as well.
Oh, yes. All right. Folks, what do you have to say to me on the issue of damages?
So, the issue on damages. Okay, so the thing he was referring to as a second omnibus motion. I just was preparing that because I was under the understanding today was the final day. You already ruled on the eviction. You were going to rule on when and the damages. Okay, so since then, there were new things that happened, such as foreclosure being posted. I've lost a lot of orders and I'm out of business. So starting damages.
You're out of business?
Yes, and I do not have enough orders to pay my lease starting April. Most of the boarders are leaving at the end of March. They saw the posting on the door. Horse owners are like horses. They're flight animals. They're herd animals, and they're all leaving, and I'm going out of business. And so I fear, because of the posting of his foreclosure on the facility, that he is foreclosing and possibly going into bankruptcy. And so what I'm asking for damages is that it be to come out of the court's account. And that, so that my understanding is damages is up to you. And I have no recourse to get any of my money. I'm out of business. I'm not going to have the money for April's lease because of the eviction.
Let me just stop you there a moment, okay? Because you know about the foreclosure?
Yes.
Council and it's a bank foreclosure?
It wasn't a bank foreclosure, but it was the lender.
Well, okay, the lender. Have they leaned anything in regard to that?
I'm not aware of a lien. There was a foreclosure sale on the 4th, which the lender purchased the property out of foreclosure. So the redemption period is obviously still ongoing, but.
Oh dear. Okay. And so when we had received, and I don't know if you were aware of it, counsel, I think it may have come in your, maybe in response to your motion to withdraw communication from your client that it was going into foreclosure. But it actually has gone through that process and then there.
Yeah, and so I just want to make sure that we're clear. So there's the foreclosure sale on the property at issue on the 4th. My client's personal house is also subject to another upcoming foreclosure sale.
That's a different one.
Those are different.
Got it. Okay. And so you have to remind me, how long is that redemption? That's not a 6-month redemption, is it? Going to be
I believe it's 3, but I
3. Yeah, that's what I was thinking. Go ahead. You were.
I filed this motion so that you would have all the information in front of you so that you could make a final decision on damages. You've already, or whatever it's called. He asked me to be, he evicted me. He asked me to leave. I'm prepared to leave. I've found a place for my horses. Most of my boarders have already given me notice. And because of the foreclosure and the eviction, the fences that have always been falling down are falling down worse. I can't keep the horses safe, but I don't have the wherewithal or the resources to fix them. And I can't go on. And I'm prepared to, if you would be willing to prorate into the court's account 10 days in April, I would be prepared to leave in 30 days from now. And
What did you mean by that, prorate into?
Well, so I usually pay at the beginning of the month for the whole month. I won't have the money to do that because majority of boarders
Gotcha.
are leaving.
I guess. Okay.
Yeah.
What you're saying. All right. This has got to be a disaster in the making, I think. When let me do this. While not holding him to it, counsel, is your client seeking to redeem the property or?
I believe in the best case scenario, yes.
Gotcha. Okay. You guys are going to have to. So let's say he doesn't, and then there's a new owner of the premises. You're probably going to have to leave in any event. So when can you guys leave the property?
I would love to leave April 10th, but I can leave at the end of March, if you're not able to give me a prorated lease payment for the 10 days of April.
What do you have? A total in escrow.
20,620.
Say again.
20,625.
I'm sorry, Your Honor, you said that's what's in the court's escrow?
Yeah, I was asking. It was 2625.
20,625.
And you folks have already paid the March payment. Right.
Quick question. The March payment, are we saying that was paid into the court's escrow?
Yes, they said they paid that.
Last one being February 5th.
So you don't have a March.
One day of March.
I didn't bring the receipt with me, but I did pay it March. I paid it. I paid it at the end of February because it was before we left on vacation. I think I paid it the last Friday of March. because we left on vacation Sunday, so I want to make sure it was in before we left.
Did you pay?
I'm sorry, the last Friday of February. We paid it cash the last Friday of February.
Did you pay it here?
Or in Saline.
Well,
It really wouldn't matter. Do you know what court you went to pay it?
no,
I do see it because you paid it here. It's not on the ROA, so.
And then it's got to be transferred over. So 5,500 additional.
So $26,125.
How long was your lease?
it was supposed to be 7 years.
Do you have how many horses are you moving?
I'm sorry, how many am I moving?
How many? Yeah.
Just my personal horses. Everybody else,
Okay, that doesn't answer my question. You're getting like that other guy.
I own.
3. So come the 10th as you're anticipating, you're moving 3 horses, or are you moving 3 horses and then some others that you're in care of? I guess I'm trying to.
There's 3 other horses that are absentee owners, and I haven't reached out to them yet because I was waiting to see when my leave date was. I'm going to reach out to them and see if they want me to take them because I'm just going to a friend of the family's and they're just pasture horses. But no, I'm not continuing this business. Does that make sense?
No, well, yeah, there's a lot more information I needed, but I'm just trying to figure out if I were to give you till the 10th, you're moving at least 3 horses, but up to 6
Yes.
total horses.
Me personally, yes.
Right. Okay. And as you're moving them, I know approximately what it's going to cost to move horses, but I don't know how far you're going. What's your cost in moving those horses?
Mm.
Just give me your 3.
$100. I mean, if that. It's my trailer, my truck,
Okay.
my gas.
So you don't gotcha.
Correct.
All right. Okay, before I make a final determination of the damages on this, any other additional argument you want to make regarding the?
Yeah, a
Okay.
couple points,
Yes, sir.
just so that when I'm on the same page and we're all on the same page. So I have back in June of 2025 was the last rent payment. And it was a partial payment that was the water heater. Subsequent to that, until this court directed Ms. Tope and defendants to submit money to the court's escrow, I believe there was the subject of a number of hearings prior to this that Ms. Tope had an escrow account personally where she was maintaining monies of some sort for June until, because I have, for example, as of March, a total outstanding rent due of $48,691.04. $26,125 of that is accounted for in the court's escrow account. The other $22,000 and some change might be in Ms. Tope's escrow account, which started this whole issue. And so
can I just stop you there? You understand what counsel's indicating about the difference in the money?
One correction, I did pay Fixing Houses LLC directly in July. I paid them the full amount in July.
Okay, but we still have a discrepancy amount. So I'm going to ask you folks a question, okay? Did you give that money of these missing, I'll call them missing, but the payments that did not get to the plaintiff, did you give those monies to Ms. Tope?
They were dispersed. That's the money that was dispersed for repairs.
Okay, but right,
They went into an
but what I said, yeah, okay.
Yes,
Hold it. You did not, okay, listen closely to my question because it's really important. You did not disperse those funds for repairs, right? You gave that money to Ms. Tope, who was holding it in whatever to then disperse for repairs or pay for it.
yes.
Okay, because hold on, there's a reason why I'm asking this, and there's a big difference. Okay, because what counsel's indicating, I believe is correct, but I just want to make sure on the record that we have it. The $5,500 that you would pay each month that you would have normally paid to the landlord in this case, there were some months you paid those funds to Ms. Tope to hold and or to use for repairs and other things.
I believe that was August, September, October, July. I paid.
Hang on a second. Hang on. Just slow down. I didn't ask what months. I want to make sure that factually because Ms. Tope's not here, factually that's correct. Because that's what I understand also, but I don't know that you've ever been asked that directly.
Yes.
This
Okay.
is the turning point of the hearing. The judge is carefully tracing where the rent payments actually went because that answer could completely change who is financially responsible. Instead of focusing only on unpaid rent, the court is now examining whether money placed in escrow was handled properly. Cases like this show how financial disputes can become far more complicated when multiple parties, trust accounts, and conflicting records are involved. If you were the judge, who would you believe based on the evidence presented so far?
Okay. So there's then this escrow, and you're saying that was 3 months, if I'm hearing you correctly, that you would have given the monies to Ms. Tope.
I would have to look at the accounting records, but I believe it was August, September, October. I believe it was 3 months.
August, September.
November, it paid support, right?
Our first payment was, I think that's right.
So just so that we're on the same page, I believe the November payment was paid to my client and it was a partial
It
payment.
was a partial payment in November. Right. So,
But I also paid
but you paid the difference of the 55 to the court. No, you paid the 55, but part of it was the check he received.
It was a double payment that month because of an error by Ms. Tope. So he received the check from Ms. Tope. We also made the payment. So that month had extra.
I believe in November, we paid the full 5,500 to the court. Is that correct? So was it 41?
You pull me
25 is what we.
He received it
41.25.
Yes.
He got 3,600.
on top of that.
So it was more than the 5,500.
It was $3,508.96.
I remember that being paid because that was a check Ms. Tope sent to him. Right.
I don't know how we got it, but my records show that we got it.
Right, that you got it. And the question was whether or not you could pay or whether or not you could use it. And because there was then the full amount, I said, you guys keep that money. The difference I thought was being paid into the court.
And so I accounted for that in my previously stated number. So I'm just trying to bridge the gap between what the court has and what hopefully should be in Ms. Tope's escrow, personal escrow account.
Okay. And that number you gave me was 48,691.40.
Not 44, so 4 cents.
4 cents.
4 cents.
In November, though, it was overpayment. Because we paid
Well-
25 and 3,500.
Well, I don't know we can really look at it as an
Okay,
I mean, because ultimately there's going to be a certain amount that should have been paid. The real question is where it went. I guess is that.
I think that's what you were gonna ask for.
Yeah, that's what it was. Okay, and I know why that happened. What I did is I think I prorated. So I allowed him to keep the check. It really wasn't a double payment. So here's what I recall doing is the money that was sent to the plaintiff, I allowed him to keep that upon the court's original. And then when ordering escrow, I ordered it pursuant to the court rules so that it was ordered prorated for the period in time. And I went back, although you paid it on the 18th, it was back around the beginning. When was our first? You didn't run the whole thing, but whatever our first date in November was, I prorated it from a date in November, which is how we came up with that number. So there wasn't a full amount that was going to need to be paid in November. All right. You complied with the escrow order. If you didn't understand all that technicality and what I just said, but I understand why that number is different. And I didn't order the whole 55 for November. All right. But in terms, okay, so here's going to be the problem. And I don't know whose problem it's going to be. And this is going to, I don't think that the monies you paid were properly put into a trust account with Ms. Tope. That causes huge problems, which I don't know what I'm going to do with it there. Because and I'm not sure the procedure, but typically and I know it's changed certainly since I've had to do it, where an escrow account or an IOLTA account is mismanaged. There are ways to the state bar of making the person whole. Now, having said that, and that's, there used to be, well, I'm sure there's got to be a way of doing that, but I just don't know how that is. Because you guys are never going to see, well, let's put it this way. You guys are never going to see that money next term. Have you asked her for the money back?
No, they're not.
I don't think that money's there. I think that that's the money that was used for replacing the sheds and all of that. So,
That's not as-
okay, no, I'm never gonna get more
But-
money back.
Here's the problem, okay? And just follow this here. Okay, and I think, guys, he's got an Alabama shirt on. Tackle him. No, I'm kidding. I don't. Under the terms of the lease, which is the basis upon which I indicated the monies, you have to pay them, right? That money should have been paid over the plaintiff. Okay,
Money should have been paid every month.
Been paid over to the plaintiff.
should have been paid
Yes.
over to the plaintiff. Okay, I ruled that.
Yes.
Okay, the problem is that it's hard. So I can't really necessarily give an offset. What really should happen in this case, right? Everything being equal and everything being what it is, and if Miss Tope were participating as one would think a member of the bar should, what should happen is the moment that I ruled that that money should have gone to plaintiff, regardless of whether she spent it on, if she did that improperly out of an IOTA account, she should then pay that money to plaintiff. Right? You guys wouldn't have to pay more. Okay. That's not gonna happen. I don't think. So while let me put it this way. She may have told you those were legitimate expenses. They weren't legitimate expenses.
I hear you.
And so what I'm toiling with, just to be honest with you, is in looking at these numbers, do I hold you accountable for that? Or what do I do with it? Now, I'm toiling with that because also, which is also part of the hearing that I adjourned to the 17th, and why I would be reluctant to let counsel out right at this moment in any event, although it may be moot, is because the bond that I set on the contempt, that would be money that Miss Tope may pay in, was specifically going to be directed toward attorney fees that were being exponentially imploded because of Miss Tope's actions. So I'm going to ask you guys to just give me a few minutes. I'm going to step off because my problem is everybody in this courtroom has been hurt by this person. And I'm trying to find an equitable way to deal with that. Counselor.
Right. I have one suggestion.
Yeah, sure.
And theoretically, how it should work is if the defendants have paid money to their attorneys in IOTA account, equitably, that's still their money, which as you alluded to, would mean that that money is no longer there. They would have a claim against Ms. Tope most likely through the bar agreements or whatever form they choose. My client does not have that remedy. And so, because we don't have a relationship with Ms. Toe. I don't have, she's not my client's counsel. She didn't hold, I don't have an IELTS account with her, or neither does my client, for example. So in this scenario, the money that was in there, the defendants, I mean, their contractual obligation is still on them. So if they pay,
I hear.
then their remedy would be, they would actually have a remedy to get it from Ms. Tobe, for my client really theoretically would not. I mean, there might be a creative way to do that, but I'm not aware of those. I've never had a situation like this before, but
You wouldn't me either. But no, I hear you. And that really had gone through my mind. But and that may be where I land in the next 15 minutes, right? But this is the second case in which Ms. Tope has been involved where people have been damaged. This is really the only one, however, that has damaged both sides, and then to a certain extent, the attorney on the other side, because your fees haven't been paid. And I want to just take a moment to think all that through. If I come up with something creative, I may come up with something creative, or I may not. I mean, I may indeed, and I appreciate what you're saying, counsel. That's where I may land, but I want to just think about that for a moment, because I, quite frankly, have never been through anything like this before either. And, you know, your client's out, your fees, plus he hasn't gotten the rental income. These folks have paid, they're out at least what that difference is, because they paid it over. So, and now, because of all of that, and I'm not saying it's the entire cause, but because of all of that, he's in foreclosure. You're not in business. It's a beautiful scenario. And it shouldn't be how things should work. And over my 26 years, I'm not sure I've seen one person cause this much damage. Court's going to stand in brief recess.
all right.
By the end of this hearing, it became clear that this case had grown far beyond a simple lease dispute. The judge expressed concern that both the landlord and the tenants had suffered serious financial harm, while also questioning how escrow funds were managed throughout the case. Rather than rushing to a decision, the court took additional time to consider the fairest legal outcome based on the evidence before it. It's a reminder that complex civil cases often involve far more than contracts. They can affect businesses, homes, and livelihoods.